The first time I heard someone claim my property line could be redefined, I thought it was a joke. Because in my world, land isn't a suggestion, it's a deed, it's pins in the ground, it's paperwork filed with the county. But that morning, the Homeowner Association proved they were willing to pretend reality was flexible if it helped them feel powerful. The day started like any other bright, clean, ordinary day, sunlight washing the street, sprinklers ticking in the distance, the neighborhood looking like it had been staged for a brochure. And I was in my yard doing the kind of quiet work that keeps a man sane, trimming, checking, resetting a few stones around a feature I'd built up over time with my own hands. It wasn't flashy and it wasn't there to impress anyone. It was there because it made the yard feel like mine, something solid and personal, something that didn't come from a catalog. I'd moved into that neighborhood after years of moving around, and the peace mattered to me, the routine mattered, the clean air and the daylight, and the feeling that I could finally put down roots without someone knocking on my door every week telling me what kind of man I was allowed to be. I knew the HOA existed, of course, everyone did, but for a long time it had been background noise, the occasional newsletter, the occasional reminder to bring trash bins in by a certain hour, nothing that reached into your life and tried to rearrange it. That's why what happened felt so sudden, like a switch flipped, because I stepped out to the front walkway and saw bright stakes in the grass that hadn't been there the day before. 3 of them planted like boundary markers, each holding a laminated notice with the Homeowner Association's logo and the kind of language that tries to sound official by being loud on paper. I walked closer and read the first line twice, then a third time, because it said the association had conducted a review of community layout conformity and determined that my yard configuration encroached on community-managed easement space, and therefore the property boundary would be adjusted for compliance, as if my fence line and my deed were just rough drafts they could edit. The notice didn't say please, it didn't say we'd like to discuss. It declared, it informed, it commanded, and that alone lit a slow fuse in my chest because I've never trusted anyone who starts with a conclusion and calls it communication. I looked down the street and saw a couple neighbors watching, not stepping in, just curious, because when HOA drama starts, people treat it like a storm, something you stay inside for and hope passes. I pulled the notice off the stake, scanned the rest, and my jaw tightened at the way it was written, the casual certainty that they could define where my yard ended and began, the implication that my feature, my layout, the way I used my space wasn't mine to decide. I was still reading when I heard fast footsteps, the kind that weren't coming to ask a question but to deliver a verdict, and I didn't even have to turn my head to know it was the HOA president because he moved through the neighborhood like he owned it. And when he reached my grass, he didn't stop at the edge like a normal person. He stepped right in, stopping close enough that the whole thing felt like an invasion dressed up as a meeting. He started talking immediately, voice sharp, words stacked like accusations, telling me the association had discovered non-conforming land use, telling me I needed to respect community boundaries, telling me the board would be correcting the line to restore uniformity, and the way he said it, confident, absolute, made it clear he expected me to nod and accept it. I asked him calmly what exact boundary he was talking about because I knew my survey, I knew where the pins were, and he waved a hand toward my yard like it was a messy desk he had permission to reorganize. He said the neighborhood had a shared green buffer, that it belonged to the community, that I'd been benefiting from extra square footage, and that the association would be reclaiming it. And while he spoke, 2 volunteers stood behind him holding clipboards and staring at their shoes like they wished they were anywhere else. I could feel my patience thinning, but I kept my voice even because I've learned that the fastest way to expose nonsense is to force it to answer specific questions. I asked where this buffer was recorded, whether there was a plat map, whether there was an easement filed with the county, whether any of this had been disclosed at purchase, and he brushed it all aside by saying the association maintains internal maps and that internal maps were enough, which was the moment I realized the real conflict wasn't my yard. It was his belief that private paperwork could override public record. I told him I had a deed and a survey and that if the association wanted to talk about boundaries, we could talk with a county assessor present, and he reacted like I'd insulted him, telling me I was being difficult, telling me I was refusing to cooperate with the community. And then he leaned into the threat, saying if I didn't comply voluntarily, the association would install new markers, revise lot usage assignments, and begin fines for encroachment. And he said it like he was doing me a favor by offering me a chance to surrender gracefully. More neighbors drifted closer, drawn by the tone, and I saw the uncertainty in their faces, because this was bigger than a paint color dispute. This was someone claiming they could move the edges of your life. One neighbor asked what this was about, and the HOA president answered with smooth certainty, telling him it was a routine adjustment and that homeowners were expected to respect community planning decisions. And the neighbor's expression tightened the way it does when a man hears something that doesn't sit right but isn't sure how to challenge it. I looked down at the notice again and noticed something that made it worse, because it referenced a community maintenance access corridor and claimed it had always existed, but the language was vague, like it was written to sound legal without actually being anchored to anything. That vagueness was a tell, because real easements have precise measurements, dates, recording numbers, and none of that was there. I asked him to provide the recording information, and he said it would be delivered in due course. Then tried to move past that by telling me the association would be repainting the boundary within 48 hours, which is a fancy way of saying they plan to show up and draw a new line in my grass like a child claiming a bigger piece of the playground. I told him plainly that nobody was placing anything on my property without proof and permission, and his face hardened because in his mind permission wasn't required if he said the right words. He warned me that resistance would be documented as noncompliance, that noncompliance would be penalized, and that I would be called to a hearing, and he said hearing like it meant a courtroom, like he had a bench and a gavel hidden somewhere. He left with one final statement, loud enough for the neighbors to hear, that the homeowner association would restore the legal boundary. And that choice of words hit me like a slap because he had no idea what legal meant. He was just borrowing it to make himself sound untouchable. After he walked away, the volunteers trailing behind him like reluctant shadows, I stood there in the full daylight with that notice in my hand and the stakes still in my lawn, and the anger wasn't just about intrusion. It was about the principle, the idea that an organization built to manage appearances had convinced itself it could manage ownership. I didn't rip the stakes out in a rage, because rage doesn't hold up later, evidence does, so I took photos, close-ups of the notice, the wording, the date, the placement. And then I walked the line where my survey pins were supposed to be, checking the ground, checking for anything disturbed, because something told me they weren't done. By the time I went inside, my mind was already shifting from irritation to strategy. Because if they were willing to claim my land with laminated paper, the next step would be physical, paint, posts, crews, some maintenance excuse that would let them step over the line before anyone could stop them, and I knew how these situations worked. If you let someone place a marker, they treat it as truth later, they build a story around it, they turn your silence into consent. I sat down at the table, opened the folder with my closing documents, pulled out the deed, pulled out the survey, and started looking up the statutes that define what a homeowners association can and cannot do. Because somewhere between their internal maps and my recorded property rights was a boundary they were about to slam into, and they had no idea it was waiting for them. The escalation didn't wait for permission. It arrived the very next morning with a confidence that suggested the homeowner association believed yesterday had settled something. Because when I stepped outside under the same clear daylight, the stakes were still there and now there were more of them, freshly planted along an invisible line that only existed in someone else's imagination, bright markers forming a crooked suggestion of a new boundary, as if repetition could turn fiction into fact. Before I even reached the yard, my phone buzzed with an email from the HOA office, subject line stamped with urgency, informing me that the association had initiated a boundary realignment process, and that cooperation was expected to avoid penalties, and the language was so carefully vague it almost admired itself, never once explaining how a private organization believed it could realign land recorded with the county. I walked the line again, boots pressing into the grass near the survey pins I knew were there. And when I brushed dirt aside and found one exactly where it should be, untouched and undeniable, I felt a strange mix of relief and anger because the truth was literally in the ground, and yet the HOA was pretending it didn't exist. By mid-morning, the HOA president returned, this time with a different tone, less confrontational but more insistent, the voice of someone who believed persistence would wear me down where volume had failed. And he started by telling me the board had reviewed the situation and unanimously agreed the adjustment was necessary for long-term community alignment, which sounded impressive until I realized he still hadn't produced a single recorded document to support it. He gestured at the new stakes like they were evidence, claiming they represented the association's official position. And when I asked again for the easement filing number or plat reference, he deflected, saying those details would be handled administratively, a phrase that meant nothing but was delivered like a verdict. Neighbors gathered faster this time, because word had spread overnight that the HOA was trying to move property lines, and that kind of rumor cuts through politeness quickly, especially among men who understand that land is the one thing you don't let someone else define. One neighbor asked outright whether the association could really do this, and instead of answering honestly, the president said the HOA had broad discretion under its governing documents, and that homeowners had agreed to those terms by living there, which was technically true in the most misleading way possible. He went on to explain that the association's maps showed a shared corridor that homeowners were expected to respect. And when I asked to see those maps, he said they were internal and not subject to homeowner review, which triggered an audible reaction from the crowd, because secrecy and authority don't mix well in daylight. The escalation took another step when he announced that maintenance crews would be scheduled to restore the boundary later in the week, carefully avoiding the word install, as if choosing softer language would make the action less invasive. And when I told him no one was authorized to enter my property for that purpose, he smiled and said authorization was implicit under HOA rules. A sentence that made my jaw tighten because it revealed how completely he misunderstood the limits of his position. As the morning wore on, more pressure followed. Another email warning of potential fines for encroachment, a voicemail reminding me of my obligation to comply, and a notice slipped under my door stating that failure to acknowledge the new boundary could result in disciplinary action, all of it designed to create the illusion of inevitability. I responded to none of it immediately because I knew better than to argue in their arena, and instead I spent the afternoon doing something they clearly hadn't expected: calling the county assessor's office, pulling recorded plats, confirming easement records, and documenting every inconsistency between public record and the HOA's claims. And with each confirmation, the picture became clearer. There was no shared corridor, no buffer, no easement. Nothing granting the association even an inch of what it was claiming. The escalation turned openly aggressive when the HOA president returned again that afternoon, visibly irritated now, announcing that my refusal to acknowledge the adjusted line would be documented as noncompliance, and that noncompliance would trigger a formal hearing. And he said it like the word itself carried weight, like a ritual that would force me into submission. He placed another notice directly on one of the stakes, making a show of it, and told me I had 48 hours to accept the adjustment or face enforcement. And the neighbors watching didn't miss the shift, because this was no longer about discussion, it was about pressure. I told him plainly that any hearing conducted without jurisdiction was meaningless, and that property boundaries are not decided by committees. They're decided by recorded instruments and law, and that statement finally cracked his patience because he raised his voice again, accusing me of undermining community order and refusing to cooperate, framing resistance as selfishness, a classic move when authority starts to slip. The escalation reached its most telling moment when one neighbor asked if this meant the HOA could move anyone's boundary if it felt like it. And the president hesitated just long enough for the truth to show before answering that the association acted in the community's best interest, which wasn't an answer at all. Phones were out now, openly recording, because men know when something important is happening, and the president noticed it too, his posture stiffening as he realized this wasn't a closed-door conversation anymore. He ended the encounter by declaring that the association would proceed as planned, that the boundary would be restored whether I agreed or not, and that consequences would follow if I interfered, and then he left, leaving behind a line of stakes that meant nothing legally but said everything about intent. As the crowd dispersed, conversations broke out quietly, neighbors comparing notes, questioning things they'd never questioned before, and I stood there in the sun looking at those markers with a new understanding. Because escalation isn't always about louder threats, sometimes it's about crossing a line so clearly that it forces a response. By the time I went back inside, my calm had hardened into resolve, because the HOA hadn't just challenged my yard, it had challenged the concept of ownership itself. And that kind of challenge doesn't get answered with emails or hearings. It gets answered with statutes, filings, and authority that doesn't need permission to exist. The crisis arrived the moment the homeowner association stopped pretending this was a paperwork issue and started acting like force would finish what words couldn't. Because on the third day, under relentless daylight that left nothing hidden, I woke to find the stakes no longer standing alone but joined by spray-painted markings across the grass, thin lines cutting through my yard like someone had tried to rewrite reality with a can and a schedule. And before I could even step fully outside, my phone lit up with messages from neighbors asking if I had authorized crews to mark a new boundary, which told me everything I needed to know about how fast the situation had escalated without my consent. When the HOA president arrived shortly after, he didn't bring pleasantries or explanations. He brought certainty, announcing that the association had begun restorative layout work and that resistance would now be treated as interference. And the way he said it made clear he believed the decision phase was over and the enforcement phase had begun. I told him to stop immediately, that no one had permission to mark or alter my property, and instead of backing off, he accused me of tampering with community space, flipping the accusation so smoothly it almost sounded rehearsed. And when I demanded proof of any easement or authority to do what he was doing, he said it would be addressed at a compliance hearing scheduled for that afternoon. A hearing I had never been notified of formally, and one that conveniently took place after the markings were already made. Neighbors gathered again, closer than before, because paint on grass changes the tone of any dispute, and several of them asked the same question I had been asking for days. Where is the recorded document? Where is the proof? And instead of answering, the HOA president raised his voice and declared that the association's interpretation of the community plan was sufficient, a statement that drew audible reactions because even people who had stayed quiet understood that interpretation doesn't override law. The crisis deepened when he announced that if I removed the paint or disturbed the markers, I would be cited for damaging community property, a threat so backwards it revealed how far he was willing to go to maintain control. And for the first time, I felt the weight of what he was trying to do, not just to my yard, but to the idea that ownership could be bullied into submission through repetition and intimidation. He went on to say that fines would begin accruing immediately for encroachment, that a lien could be considered if compliance wasn't achieved, and that the association's legal counsel supported these actions, though he never named that counsel or produced a single written opinion, relying instead on the authority of saying it out loud in front of witnesses. The neighbors reacted strongly this time, openly challenging him, asking whether liens could really be placed over disputed boundaries, whether any of this had been approved by a vote, and whether they could be next. And instead of calming the situation, the president snapped that discussion was over, that enforcement was underway, and that anyone interfering would be documented, a move that turned a tense crowd into a unified one. Phones came out openly, recording the painted lines, the markers, the declarations, because the crisis had crossed from disagreement into something that needed to be preserved exactly as it happened, and I could see the president noticing the cameras, his tone sharpening as he tried to reassert dominance through volume. He attempted to conduct the so-called compliance hearing right there in my yard, reading from a printed page, declaring findings, announcing violations, and stating penalties without notice, quorum, or jurisdiction. And the absurdity of it didn't lessen the danger, because pretending to hold a hearing was his way of manufacturing legitimacy after the fact. I told him clearly that the hearing was invalid, that property boundaries are not subject to HOA hearings, and that he was trespassing, and for a brief moment the yard went silent, the kind of silence that hangs before something irreversible, because he stepped forward and reached toward one of the painted lines as if to emphasize his claim. And I stepped forward too, telling him not to touch anything further. That moment, brief and sharp, was the edge of the crisis, because everyone present understood that one more step would push this beyond administrative overreach and into something much more serious. He stopped not out of respect but uncertainty, realizing that whatever shield he thought his position provided was thinning fast in front of witnesses and cameras. And instead of backing down, he lashed out verbally, declaring that the association would finish what it started, that resistance would only increase penalties, and that I was putting myself at risk by refusing to cooperate. As he walked away, leaving the painted line cutting across my yard like an accusation, the neighbors stayed behind, talking in low voices, comparing what they'd just seen to their own experiences. And the realization spread quickly that this wasn't about aesthetics or planning, it was about control exercised without boundaries. Standing there in the sun, looking at my yard altered without permission, I felt the shift inside myself from defense to action. Because this was no longer something that could be managed internally or reasoned away. It was a documented attempt to redefine ownership through intimidation, and that carries consequences far beyond neighborhood politics. I gathered everything again, photos of the paint, videos of the declarations, copies of the emails and notices, and I added something new to the file, a timeline showing exactly when the HOA moved from claims to physical action, because that distinction matters when authority is questioned. The crisis wasn't that my property had been marked, it was that the homeowner association believed it could do so and get away with it, and beliefs like that only survive until they collide with something stronger. As the afternoon wore on and the street returned to uneasy quiet, I knew the president thought he had forced the issue, that he had pushed me into a corner where compliance would feel easier than resistance. But the truth was the opposite, because by crossing into physical alteration, he had created the evidence that would end this entirely. I went back inside under the same bright daylight that had exposed every lie so far, opened my documents, and made the call that changed everything, because once legal boundaries are challenged openly, the response doesn't come from within the neighborhood anymore, it comes from the law, and the law doesn't argue, it corrects. The turning point didn't come with an argument or a confrontation, it came with precision, because once the homeowner association crossed from claims into physical alteration, the path forward stopped being emotional and became procedural, and that shift changed everything. Early the next morning, under the same sharp daylight that had exposed every overstep so far, I received confirmation that my report had been formally logged, not as a complaint, but as a notice of attempted boundary interference by a private organization, and the language alone told me the situation had moved beyond neighborhood theater. I organized everything one final time, the notices, the emails, the recordings, the photographs of the painted line, the survey pins in the ground, the deed with its recording number, and the statutes that define exactly where a homeowners association's authority ends. And when it was all laid out together, the contrast was almost absurd. Vague internal claims on one side, recorded public law on the other. The arrival of the state representative later that morning changed the atmosphere instantly, because real authority doesn't announce itself loudly, it simply arrives and starts asking questions that demand real answers. Neighbors gathered again, but this time there was no tension in the air, only expectation, because everyone could feel that something definitive was about to happen. The representative walked the yard slowly, examined the painted markings, located the survey pins without being prompted, and reviewed the HOA notices still present, and then asked the question that cut through days of noise in a single sentence: who authorized the alteration of a recorded property boundary? When the HOA president arrived, clearly unsettled by the unfamiliar presence, he tried to assert control immediately, insisting the matter was internal, claiming the association had authority under its governing documents, and stating that the markings were temporary, but the representative didn't argue, didn't react, just listened and documented every word. Then calmly and publicly, he explained that property boundaries are governed by recorded instruments and state law, not internal interpretations, that no homeowners association has the authority to redefine, adjust, or mark a boundary without a legal process involving the county, and that any attempt to do so constitutes unlawful interference. The explanation wasn't dramatic. It was surgical, citing statutes by number, referencing established precedent, and clarifying that intent didn't matter when actions violated clear legal limits. When the president tried to interrupt, insisting the board supported him, the representative stopped him immediately, stating that board approval does not legalize an unlawful act, and that individuals who direct such acts can be held personally responsible. And that statement landed heavily because it reframed the situation from an organizational dispute to individual accountability. The turning point became unmistakable when the representative ordered the immediate cessation of all HOA activity related to my property, instructed that the painted markings be documented and then removed, and issued a written directive prohibiting any further action pending review, and that directive wasn't a suggestion. It was enforceable, effective on the spot. Volunteers who had planted stakes and assisted days earlier now removed them quietly, not under threat, but under instruction, and the symbolism of watching invented boundaries disappear under the authority of law wasn't lost on anyone present. The representative then requested copies of the HOA's bylaws, amendments, internal maps, and enforcement procedures, specifically asking for documentation supporting the claimed authority to adjust boundaries, and the president hesitated, visibly shaken, because internal maps and verbal approvals don't survive legal review. As neighbors watched, conversations began quietly among them, men comparing experiences, recalling fines and warnings that suddenly made sense in a new light, realizing that what they had seen here might not have been isolated. Before leaving, the representative addressed me directly, stating clearly that my property line remained exactly as recorded, that no action was required on my part, and that any further interference would trigger immediate enforcement, and that clarity felt less like victory and more like balance being restored. The HOA president didn't argue as he walked away this time, didn't threaten, didn't posture, because for the first time since this began, his authority had been corrected publicly by something he couldn't intimidate or reinterpret. As the street slowly returned to quiet, the turning point settled in not as a dramatic climax, but as a permanent shift, because investigations don't end when officials leave, they begin. Standing there in my yard under the same bright sun, looking at the ground where a painted line had tried and failed to replace a legal boundary, I understood that the conflict had moved completely out of the HOA's hands, and that whatever happened next would be governed by law, documentation, and accountability, not volume or confidence. And once that shift occurs, there is no going back to the way things were before. The resolution unfolded without drama, but with a finality that made everything unmistakably clear. Because once the investigation moved forward, the homeowner association could no longer hide behind meetings, emails, or invented interpretations, and the consequences followed in steady daylight where everyone could see them. Within days, official findings were issued confirming that the association had no authority to redefine property boundaries, no authority to mark or alter private land, and no authority to threaten enforcement based on internal maps or assumptions, and those findings didn't read like opinions, they read like corrections. The HOA board was forced into emergency session, not to debate aesthetics or compliance, but to address exposure, because the documentation showed a pattern of unilateral decision-making that placed the entire association at risk. And for the first time, the president wasn't directing the meeting, he was answering for himself. Neighbors attended in silence, listening as the facts were summarized, The painted lines, the unauthorized markers, the false claims of authority, and the board members' expressions shifted from loyalty to concern as they realized how close they had come to real legal consequences. The board voted to immediately rescind all actions related to my property, formally acknowledge the recorded boundary as controlling, and issue written notice to homeowners clarifying that property lines cannot be altered by HOA action under any circumstances. A decision that restored clarity not just to my yard, but to the entire neighborhood. That vote was followed by another, quieter but more consequential, because accountability doesn't stop at policy, and the president's actions, now documented and reviewed, could no longer be excused as enthusiasm or misunderstanding. He was removed from his position by unanimous decision, effective immediately, citing abuse of authority, exposure of the association to liability, and violation of governing limits. And the room didn't erupt or celebrate, it simply exhaled because everyone understood something unhealthy had finally been corrected. Notices were sent out the same day explaining that no homeowner was subject to fines, penalties, or enforcement related to boundary claims, and that any such notices previously issued were void, and the relief was subtle but real. Conversations on the street grew easier, shoulders relaxed, and the fear that had kept people quiet for years began to lift. State oversight continued long enough to mandate training, transparency requirements, and written limits on enforcement authority, ensuring that no future board could repeat what had happened without immediate consequences, and those changes reshaped how the association operated, turning it back into what it was always supposed to be: limited, predictable, and accountable. As for my yard, the outcome was absolute. The painted lines were removed, the grass restored, and formal documentation was issued reaffirming the boundary exactly as recorded, backed by clear penalties for any future interference. And that document did more than protect my property, it set a standard that couldn't be ignored. Life returned to routine under the same bright daylight where the conflict began, but the atmosphere was different now, quieter, more grounded, because the illusion of unchecked authority had been broken. The former president stopped appearing altogether. No more confident strides across lawns, no more declarations, no more clipboards, just absence, the clearest sign that his power had never been as solid as he believed. Standing in my yard again, looking at land that had briefly been treated like a suggestion instead of a right, I understood that the real victory wasn't personal, it was structural, because once legal boundaries are enforced, everyone benefits. The story didn't end with shouting or humiliation, it ended with correction, with law doing exactly what it's meant to do when someone finally insists on it, restoring order where overreach had taken hold, and proving that no organization, no matter how confident or loud, gets to redefine what it doesn't own, because in the end, authority without legal boundaries always collapses, and when it does, it leaves clarity in its place.